I think, while we're pointing out how big of a piece of shit Eric Greitens is, I think we're obliged on behalf of Mark to point out that Eric Greitens went to Duke.
Just the worst people went there.
Of course he did.
Just
Connor Southard is the only good Duke graduate, right?
I mean, big asterisk there, but yeah. Sorry, Connor. Please cut this out.
Connor Southard and Richard Nixon.
That's right.
The two best Duke graduates.
Hey everyone, and welcome to episode 8 of Mike Dicta,
Wait.
9.
America's
9.
What? I that can't be.
I know you don't count 8, but
Seriously, so we're gonna go. So we are gonna go with 8 counting, huh? 8 is canon.
yes.
All right, fine. Welcome everyone to episode 9 of Mike Dicta, America's best named legal podcast. I'm your host, Charles Starr. I have with me, as always, except for the incredible episode 7, Tarik, the Hell Dude.
Hello, everyone.
Back again. Appearance number 4, I believe. We have Christina.
Hey, y'all.
Since we are counting episode 8, I think this is number 3 for Adam.
Hey, folks.
And joining us for the first time, welcome Pat to the show.
hi, everybody.
So we've got 3 cases, as always. Today, we're going to start down south, where I think we found ourselves a few times before. This time in Alabama, where I know we dealt with Roy Moore before. But this time, we are in Jefferson County, where the 11th Circuit just refused to allow the town of Gardendale to excise itself from the Jefferson County School District on the grounds that the entire town of Gardendale is too racist for the 11th Circuit Court of Appeals.
That's racist.
It was something.
The movement was literally they called themselves a secession movement, which is really convenient because you can just, keep the same name. So you're talking about who the bad guy is.
Love to secede.
Yeah, it was a really crazy pattern where Jefferson County has been under a desegregation order based under court supervision, I suppose. Jefferson County has been under court supervision since before the 11th Circuit existed.
That's right.
Under the 5th Circuit before, I think, right?
Yeah. The 5th Circuit, Georgia used to be, Alabama, Georgia, a couple of other, Florida, used to be in the very large 5th Circuit before the Southern population exploded, and they had to split the 5th Circuit into 2. And so this is a really long-standing order, and Jefferson County, among other things, has to get approval before things like this happen. And it really feels in a way like the Gardendale kind of just lost a game of musical chairs, because there have been a bunch of towns that have successfully been able to secede from the Jefferson County School District, all really on the same grounds that Gardendale was trying to get out. But this last attempt by Gardendale kind of pushed the numbers in Jefferson County a little too far and pushed a judge sort of a little too far. And they were finally the first one who got kind of caught and are not allowed to leave the Jefferson County school.
Yeah, I mean, you can kind of tell that they were sort of expecting just to have a hearing, just be an in and out thing. Hey, we're going to make our own school district that's super racist. And then they were like, oops, there's actually going to be a trial about it. So, they were totally caught with their pants down being racist. So...
Yeah, I mean, the history, as the 11th Circuit tells it, is that they they really seemed conscious of the fact that they could lose. And they would have all of these discussions about how not to lose. They were like, well, there are these diversity transfers, and we should probably allow these diversity transfers, or the court, is going to stop us. And then they would be like, nah, no diversity transfer. And then North Smithfield, which is like the relatively certainly black municipality just outside of Gardendale, which has been going to Gardendale schools since the early 70s. They're like, well, we should probably include North Smithfield because they've been part of our district forever. And if we cut them out, then the court is definitely going to see this as racist. And then they cut them out anyway.
Yeah.
Right.
Like each time, so there's this whole record of them noticing that they should probably cover their tracks a little.
Well, they just don't care because it doesn't seem like there's any indication that they have to care in the 11th Circuit until now.
Well, I think what happened is that they got caught, committing the cardinal sin in America, which isn't actually being racist, but appearing to be racist.
Ooh.
And quiet part loud. Right. It's like that's how all of these things resolve themselves, with people going on record. I mean, one of the more important exhibits in the case was like essentially a Facebook meme where it was just like a vulnerable white child.
Yeah, a little white girl. Yeah.
And a vulnerable white girl, and all of the ills that the larger school district presented for her future.
Jesus, who makes these? Who's like, yes, this is a good idea.
Of the opinion has the meme, which is like a little white girl with her backpack and her very 1950s dress, and the text says, "Which path will Gardendale choose? Places that chose not to form and support their own school system," and then it lists, a group of towns that are in the unified school district. Communities that chose to form and support their own school system and are listed as some of the best places to live in the country. And then, it lists places that, did secede. And then on the bottom, in a black box, is on which list will you place Gardendale?
Oh.
I mean, it's essentially a white genocide meme without the overt racism.
Yeah, I mean,
it's the subtext is what they're going for here.
No, it's a white genocide meme with all the racism.
Right. It's where it's like where they think it's where they think they're being savvy, right? But even then, they can't stop themselves from putting, like the Little House on the Prairie girl on the poster, because they can't stop telling on themselves. And so they get caught. And the procedural history here is kind of interesting, because the district court found that they had improper racist motives and sort of didn't allow them to secede. And someone who I didn't read the opinion below, but I think, I'm sure at least one of you did. Like the district court crafted its own remedy, right? Which still which sort of kind of allowed
split the baby,
but under supervision. Yeah.
I mean, does anyone want to talk about, before we get into all this, like what secession means? Because this is not something that happens in the rest of the country. This is I think sort of like a Southern kind of maybe Alabama only way to be really racist.
I believe the New York Times, there's a New York Times article in the magazine from this past September that I believe Christina sent around to the group beforehand. A hat tip for that discussed the background here. And essentially I believe in the coastal cities, and especially in the Northeast, you have a lot of school districts, I believe, that are attached to municipalities and that are based on county structure. Whereas I believe in the South, a lot of this is, essentially you have Jefferson County, and then there's a school district that encompasses the entire county rather than having kind of an amalgamation of different towns and other districts. Right. And because a county itself in the South can be pretty racially diverse, despite some of the obviously attempts to fight against desegregation over the last 60 years or so since these orders came out, or 50 years or so since these orders came out, they had slowly desegregated. Whereas in the Northeast, you could kind of, like we talked about gerrymandering in one of the earlier episodes, you could gerrymander the districts in a certain way that you didn't have, or that you could kind of escape this initial presumption, I believe, of getting around the order.
Right.
Yeah.
And so,
go
ahead.
So what had happened was that the orders worked, and
these are the orders back in like the early 70s.
Right.
Yeah, this goes back to 65. Right?
The orders go back to Brown, but I mean, these orders stay in place for a long time. I mean, the Stout order has been in place since the 60s. Brown itself lasted
71.
until 1999. So the orders sort of reached their peak power in the early 70s, before the sort of anti-busing movement sort of started to push them back. And then the Supreme Court came out in Milliken v. Bradley in a Detroit case, saying basically that, de facto segregation is okay as long as it's not intentional. And with that, the orders sort of the crack was there in the system for folks to sort of seize upon, right? To say like, okay, well, we can do this as long as we don't say the racist things. We can be racist.
Yeah, it's really interesting how they frame secession. Like it just goes back to this like conservative bullshit where it's all like taking back local control, which is like the same line they've been pandering literally since the Civil War. So
it's states' rights in the 21st century, essentially. It's like it's the Southern strategy, except on a super local level here.
Exactly.
You're not like hell. Even when Lee Atwater came out with the Southern strategy in the 70s, he mentioned things about busing and segregation. It's like, you can't use these words. Say local control. Say states' rights. You'll get the buy-in from white suburbia that you wouldn't get otherwise.
Yeah. So desegregation in the U.S. reached its actual peak in the late 80s, which is when there were still enough of these desegregation orders that were in place, based on lawsuits by the NAACP and, formerly vigorous DOJ Civil Rights Department. But the, Reagan and Bush II administrations really stopped trying to enforce the orders, and almost half of them were lifted during the George W. Bush administration. Yeah. So there were, I think, around 600 or so in place in 2000, and now there are 300 and something.
Well, I know.
And for the record, the Stout order for Jefferson County was challenged before, and they explicitly kept it in place.
Yeah.
Right. They basically said progress is being made, but we're still watching you. Kind of because I think whatever judges were reviewing it at the time saw exactly this coming down the pike. And so, and it just sort of was borne out as, one municipality after another started peeling themselves off. And then Gardendale tried to follow their lead, and then couldn't keep themselves from doing it in the most aggressive and obvious way possible.
Oh, there's a white community that they were trying to scoop in too, right? I mean, like they were expressly trying to push out these other communities, and then but Mount Olive, this community over here, we should bring them in, right? I mean, there was no effort whatsoever to hide the racial tenor of what they were up to.
And they tried to do it because it's all about trying to work on the technicalities, right? Gardendale is a municipality, so they try to base it strictly on their municipal lines. And since North Smithfield, the black town, is outside of those lines, they would cut them out. And Mount Olive, they tried to get in by essentially proposing that the town be annexed into Gardendale. And so there wouldn't be a Mount Olive anymore except as a Gardendale neighborhood. And so it could stay inside the school district.
I believe there was even some tension involving North Smithfield because the proposal that was submitted to the court involved keeping some North Smithfield kids in the high school for several years, at least until they finished out, I think, their term. And some of the Gardendale residents were like, whoa, whoa, whoa. We want to be like super racist. We don't even want to pretend that we're giving this, kind of veneer of treating people equally. And they said, all right, well, if I knew that we were going to allow the North Smithfield kids to stay, I wouldn't even signed on to this thing.
Yeah. I think that had popped up on the, the Facebook page,
Mm-hmm.
right, of the nonprofit group, which is called Focus, which stands for Future of Our Community Utilizing Schools. It's really clunky and, but at least I guess is shorter than the original 14 words.
Oh, got him! Pew pew. Well, so what I kind of want to talk about, like just the district court opinion was sort of interesting to me because, like, it really did try to do like a split the baby sort of decision where they attempted to both like say like, yes, what Gardendale is doing is racist. And like, here's all the reasons why it's racist, but we're going to sort of let them do it. But like, in a way, like by letting them do it, that means that they get to have control over the situation, which just sort of shows like, how like weird our legal system is and like how like you almost have to work on the technicalities to get anything done, especially.
So wait, now how did they split what was the method that the district court used to sort of control the sort of pace of the Gardendale secession?
So, and it wasn't just the order itself, but actually at trial, there was a moment where the judge took not a break, but she took her privilege during the questioning of the school superintendent who had been chosen by the nonprofit parents group.
Mm-hmm.
And this is a school superintendent who had come from rural Illinois, who had never in his entire career worked with or hired a black teacher. And she took a moment during his questioning to ask him about Brown v. Board and, have him explain in his own words what the decision meant. And she literally read from the decision to him while he was on the stand.
Because he couldn't explain it. Because he didn't know what fucking Board v. versus Board of Education was. It was awful.
It was really embarrassing.
So you can tell, you could tell from her opinion, you could tell from the trial that she knew exactly what was going on. But I think what happened with the decision was she thought she was going to lose. So she put a sort of...
She let them have two elementary schools, I think.
Yeah.
Then with an option to get buy the high school from the county in 3 years if they have a desegregation.
Yeah, that was,
And they had to hire, I think, like a certain number of black teachers, and they had to put in a certain number of black members of the school board.
But I think the most important part was that they're they're still under judicial control. Basically, there's still an order on them. Is what the
she created she created an order kind of sua sponte that all right, well, this school district is new, but we're going to put a desegregation order in place kind of at the start to make sure when you that you're not that you're at least kind of hiding, I guess, your overt discrimination there.
Well,
and I guess that what I recall of the grounds for doing that is she thought that she might lose on appeal on the grounds that the county itself could be removed from the desegregation order or from the court supervision. And once the county was removed from court supervision, then all of the municipalities could go their separate ways. Yeah. And so as a way of beating that to the punch, she was going to stick a new order on Gardendale and keep it under her supervision. And what I thought was interesting in the 11th Circuit is they're like, well, the district court's really not allowed to do that. They can't jump the gun and guess. And so technically Gardendale lost because they said, you're still subject to the Jefferson County order. You have all of this evidence of racial motivation in your secession. So we are going to undo the complicated shit that the district court did and just say, no, but they kind of, I think, in the way they wrote the opinion, I just had this like wave of nausea where I felt like the 11th Circuit is ready to declare Jefferson County like a unitary district and remove them from supervision soon anyway.
Yeah.
Like the kind of hint was what the district court, and I don't know why I feel that, probably because it was written by William Pryor. But I just felt like they were just hinting that it's certainly possible that Jefferson County could get under the yoke of the court supervision, and then none of this would matter.
For everyone listening who's not a lawyer, William Pryor is very bad.
He was one of the torture memo guys, wasn't he?
Not great.
But the court went on to say how this high school that was at issue that they had, I guess, built back in 2010 that was in Gardendale was like a model of desegregation, and that this is what they wanted to see. And I think that Charles is 100% correct in that, you know, they're really hinting at what's going to happen in the next year or so, where it's like, all right, well, look, we kept the racists from creating their own school district. Therefore, we're going to lift this desegregation order.
One thing that you know that you mentioned though that was irritating to me was Gardendale couldn't afford to build its own school.
Yeah.
Right. So they waited to do all this after they got the county to foot the bill for that school building, right? And they were just trying to hijack this brand new state-of-the-art high school out from the county after it was built, right?
It's like literally swindling.
And they just keep it for the white kids.
What's more American than having someone else pay for your nice shit and then running away and sticking them on the bill?
So it really was a sort of, it was just an amazing string of facts in the case, you know, because the undercurrent of all of this is that North Smithfield was pretty white for a while. And then as soon as the demographics changed a little, they changed a lot. And so, you know, North Smithfield was, you know, persona non grata in Gardendale. And like all of these surrounding towns are incredibly white. And Gardendale itself is like really white. And they like Gardendale played a lot. I guess there were some like Gardendale isn't 100% white. And there are, I guess, black parents who live in Gardendale proper who were on board with it. And I guess that was really important to the Gardendale briefs. They're like, look, even our local blacks are in favor
So
of
there was
this.
this,
You know, in a really sort of grotesque way of justifying their own racism.
During the trial, they had a woman who was... she had a PhD. She was an African-American woman who had grown up in Gardendale and was an advocate for the creation of this independent school district. And the attorney for the plaintiffs, you know, during cross-examination, was questioning her and was essentially said, you know, you're eminently qualified. You have years of experience working in public education. Are you a member of the Gardendale School District Board? No. Did you apply? Yes. Did they hire a white person instead? Yes. Are you more experienced than the white person they hired? Yes. Do you think that race played did race play a factor in your decision, in their decision to not hire you? And she said yes. And this was a witness for the defense.
and the judge asked her that. Like the judge asked her that, which is incredible.
Oh, okay. I thought that was the plaintiffs.
No, so the plaintiffs were questioning her, and then the judge had to restate the question. Like,
okay, yeah, that was an incredible exchange, though, and I think that really kind of, you know, pulled the veil away from these motives and said, you know, look, behind all of this is that sort of naked racism that, you know, that's absolutely abhorrent.
it makes you just like can we just get rid of Alabama? Like, I don't,
Little.
Well,
no, sorry
actually,
to our Alabama listeners, but like move.
Hey, actually, I want to say Mississippi has the most school districts that are still under desegregation orders at 61.
Whoa.
Followed by Alabama at 54, and then again coming in with the bronze medal is Georgia with 48.
Hell yeah.
Which is interesting because back in the back in the VRA pre-clearance case, this is the town, and it's like a water district in Texas, so I can't remember the name of it. Shelby? No, it's not Shelby County.
Shelbyville?
No, that's the Simpsons.
Shelby County, I think was
that was the Roberts VRA case, yeah.
Right. So in the VRA case, I just remember Roberts basically asking the Justice Department attorney, basically being like, so are you saying the South is still worse than the North? And like, it was it was uncomfortable on two levels. One, because of the statistics Pat just cited, where all of these southern counties are still under desegregation orders in their school districts, which tells you probably something about where they stand on their voting rights too. But also because I think what gave weight to Robert's argument and his ability to kind of play dumb about why certain states were under pre-clearance requirements and others weren't, are that as the kind of Rust Belt has become increasingly run by Republicans, they just keep passing horrible voting rights restrictions, and there doesn't seem to be a good reason why Alabama should be subject to pre-clearance, but say Scott Walker's Wisconsin shouldn't be.
Right.
And so it ends up being this thing where the thing that makes it discriminatory against the South is that as Republicans have started taking over the North has become more explicitly racist in their design. And so the idea of sort of discriminating between the states, which is just a dumb equal protection argument to begin with, like you have a hook to hang it on now, as like all of these terrible things happen in the North. You can just sort of wave away the sort of uniqueness.
It's a very bold strategy just to like cover everything and shit, and then like tell someone like, well, I can't clean it up because it's too dirty now. I mean, which is essentially what they're doing. I mean, like, I'm from Texas. My high school didn't desegregate until literally the 1980s. The South is like not good, and you know, it's fucking depressing that we're still talking about this kind of stuff in 2018. But it sort of reflects a nationwide trend, sort of going back to segregation. Like, I mean, this is something that's happening actively all around the country. And so, you know, it's fucking depressing.
Right. And, you know, I think that I would also want to point out that, you know, a lot of these court orders are, you know, in places, you know, counties all across the South. But, you know, because the northern cities, you know, the older northern cities, the places in the Northeast, on the Eastern Seaboard, you know, because they, you know, didn't have those orders in place or anything like it, you know, what you have are, you know, some of the most segregated school districts in the countries are not those in the South, but they're those in cities like Chicago, New York City, in Washington, D.C., where I live. Mm-hmm. I think the majority of public schools are what you would call apartheid schools.
Yep.
That is, they have at least 99% of you know, either one of one race or the other.
Well, I think Vox of all places had something that came out, I guess, a couple weeks ago or a month ago, where you could basically put in your zip code or your address, and it would show you whether the school district that you were in was segregated or was designed in a way to have segregation. And you can say, all right, is this representative of the general population, or is it set up in kind of a fashion where we're, you know, again, essentially gerrymandering the school districts to get racial preference in a certain manner? And, you know, I want to say, I live in Alexandria, Virginia, and my school district, we came out on top. So, you know, good for us.
Congrats.
Yay.
My former location in Arlington County, unfortunately, was very segregated. So bad on you.
I couldn't tell whether you were being ironic because like coming out on top in the way we've all been talking about this. I mean, it's, you know, I mean, I'm in Brooklyn, and the Brooklyn schools are, you know, very, very segregated in the way that the neighborhoods are in the way the neighborhoods are very segregated. And, you know, the district where my son is in school is like a really, really big district, you know, and it spans from Sunset Park all the way, you know, up to like Cobble Hill. And there are real dramatic differences in the sort of in the student populations and the resourcing. And I think there's a lot going on within the district trying to figure out how to reconcile that. Certainly at like the middle school level, like high school admissions are like not so neighborhood based, and it's really hard to do it with elementary schools because everyone wants to walk to school. And it just becomes very politically difficult. But once you're in middle school and can kind of take the bus yourself, like changing the admissions around is where they're trying to sort of hit that so that you can kind of get kids a little more mobile and, you know, balance out the school population.
Yeah, that's what I found so sort of almost archaic about this whole conversation is, you know, it's sort of imagining a time in the U.S. where, you know, courts are going to get down and tell you, you know, you've got to do this and move these kids here and desegregate. I mean, you know, just sort of thinking, you know, the case started back in 1965, right? And the lawyer at the trial in this case today was the lawyer who tried the case back in the 70s, right? And we're still grappling with all these issues, and it's just crazy to me to imagine a court in this day and age entering these sort of sweeping orders, declaring segregation to be something bad and trying to fix it.
Right. I mean, a lot of them are Warren Court era decisions that are being handed down by the district courts under, you know, then more muscular Supreme Court precedent. And, you know, now the sort of main or the most recent school segregation precedent from the Supreme Court is parents involved, which is, you know, the home to the most John Roberts of all John Roberts opinions, where he says the way to stop discrimination on the basis of race is to stop discriminating on the basis of race.
Fucking get him, John. That's
Such
right.
a reductive statement. Oh my God.
And I think one of the things that was interesting about this case to me is that like the schools actually desegregated. I mean, I don't know, like, you know, New York is just south of Yonkers, which was the subject of the HBO series Show Me a Hero. And Yonkers never did desegregate. Exactly. They just literally didn't do it. And they just sort of waited out the courts. You know, like they finally had like a city manager who was willing to do it, but the population fought it. And then he got run out of office. And then like the courts just sort of ultimately threw up their hands and nothing happened. So, you know, and it's just sort of mind boggling to me that like Yonkers had the wherewithal that Jefferson County didn't.
Yeah.
Like Jefferson County is like doing it through the back door, though I guess we probably send troops into Jefferson County and no one's sending troops into Yonkers. There's Tarik. Tarik was leaning over away from the camera.
I'm back.
All right, welcome back. Our second topic today is not a thing you really expect to hear. Usually, when a sitting governor is frog marched out of his own office, it is for corruption, not for revenge porn. But that is not our current situation.
Not at all.
As Eric Greitens, Governor Maureen Todd, has been arrested.
That's Governor Navy SEAL Todd.
That's right.
Yeah, that's true. I don't want to get the sticklers for branch accuracy.
Andy's going to be mad.
At the expense. Yeah. I mean, look. The fact is, I think meme accuracy is more important than correctly identifying his branch of service.
100%.
That's right.
But yeah, the governor of it's Missouri.
Missouri.
Right?
Missouri.
Missouri.
It's like, and all of a sudden I'm having like a crisis of confidence. Governor Eric Greitens of Missouri has been arrested for photographing a woman he was having an affair with naked and making it accessible by computer. It's a very sort of specific charge, which essentially amounts to non-consensual picture taking and sharing.
It's so hard to write these revenge porn laws in a way that is like, like prosecutable or like able to be enforced. And this,
well, it's
yeah. Go ahead.
I think it's hard to tell here whether, and this is like, I mean, Greitens has a motion to dismiss pending because he says basically this isn't a revenge porn.
Right.
Mm-hmm.
Right. His defense, he's not even addressing, like he denies it on the facts. Yeah. Right. He sort of says, first of all, I didn't do any of the things she says I did, but that's not particularly convincing. It's like, in light of other evidence that we'll get to later. But he also says this specific statute was not written as a revenge porn law, and it's never been used as a revenge porn law.
No, it was a peeping law, right?
This is a peeping
Yeah.
Tom
Exactly.
law. This is for people who set up cameras in dressing rooms or who take upskirt photos or who do all of these surreptitious gross things, but the particular gross thing that I did, which is
fully consensual.
Which is blindfolding my lover and taking her picture without her knowledge and then threatening to expose it. None of that is covered by this specific statute. And how dare you, sir? How dare you lump me in?
I could be an
with
awful
these
perv, but it's not a
peeping
crime.
Toms.
Like, it's just like the motion to dismiss itself is just ridiculous. Like, it just goes into this really long statutory interpretation argument, and like, and you can so like clearly see he's trying to like gloss over the fact that he's a nasty, like abusive perv who took a picture of like someone that he was having sex with and then threatened her with it.
Well, I thought it was very interesting that a constitutional conservative would stray so far from textualism and rely on the legislative history in his support, in support of his
Scalia is rolling in his grave.
In fairness to Governor Greitens, he was a Democrat. And then,
that's true.
And then switched parties only recently. So, his dedication to textualism may be less than rock solid.
You can take the man out of the Democratic Party.
This motion to dismiss also was ready to be filed, I think, the day he was arrested. So, he had sat down with his attorney, and his attorney had it, ready to fire it off, which I think goes to the sort of factual circumstances of the case and his very thin denials of that.
Yeah, I mean, like the fact is that the story broke because the woman he was having an affair with confessed to essentially confessed to the affair with Greitens, which he has admitted to, but to her husband, who confronted her about it. And her husband was taping her without her knowledge. And so as he got her to admit the affair, she also said, and this other thing he did was I couldn't tell anyone about it because he had me tied up and blindfolded, and all of that was fine because that was the kind of kink we shared. But then I sort of, through the blindfold, saw a flash and heard a click. And then he told me that he took a picture of me naked and that if I told anyone about this ever, the picture would be everywhere. And he says he's deleted the picture, but she has no real proof or knowledge whether he did or didn't. And the charge seems to imply that at least at some, I don't know if they're implying that they recovered it or that they recovered evidence that he uploaded it to the cloud or something. But they said that the picture was the charge in the statute that he was charged under because it was accessible by a computer.
Yeah, it sounds like it was just uploaded to iCloud or something. I mean, which, like, if you read the statute, like, I mean, that sounds like it could be like within the letter of the law, like what they indicted him for.
Right. Yeah, I mean, I think that, you know, one thing about the indictment is that because he hadn't, I don't think, shared it with another person, they were sort of left to go with the misdemeanor version of the invasion of privacy charge rather than the felony version, which meant the statute of limitations was shorter, which meant that they were working on a quicker timeline. So they had to, I think they had to use their own sort of private investigators because the criminal investigation wasn't moving quickly enough. So they basically had to file this, I think, within like a couple months, or else they would have, you know, lost the opportunity to charge him.
Yeah, I think it was late March. I think it was late March when the statute of limitations would have expired. I mean, the way he hangs, the statutory language that he hangs this on is that it says that the person had to have an expectation of privacy when they were photographed. And so he reads that in the context of the Peeping Tom statute as saying, like, you have an expectation of privacy in a dressing room. You have an expectation of privacy in a locker room. You have an expectation of privacy in all of these sort of private places. But you don't have an expectation of privacy when you are consensually naked with a person you are having
which
sex
is
with.
terrifying. Like, Jesus Christ. Like, that's like one. I mean, like, I expect to have some sort of privacy whenever I'm like.
They distinguish it between being seen naked by that person. Like, they just try to slice it razor thin, where they're like, you were not expecting to be private from the person who took your photograph.
Right.
And if the photograph itself is a violation, there may be a statute for it, but it's not this one. And this statute says that you have an expectation of privacy in the place where you are. And while if a third party took a picture of her with the governor, that would have been subject to the statute because the two of them would have had an expectation of privacy from the third person. She did not have an expectation of privacy specifically with respect to him. And so that takes it outside of the statute. It's just this really narrow way.
Right.
They're trying to get him outside of the coverage of the statute.
Yeah, I mean, they're sort of reading in, I think, like a very kind of antiquated, or not. No, I mean, I shouldn't even say very antiquated, but they're reading in like a very kind of contract-based theory of consent into this, right? They're basically saying like, well, you know, you agreed to do sex with him, and like therefore you agreed that anything that might happen, you know, while you're, you know, doing sex is totally fine.
Yeah,
totally
it's like she checked yes to all.
While
yes.
you're tied to his Stairmaster, anything goes.
I believe the line in the motion to dismiss is, the whole point of the sexual activity is to be viewed by the other person and to jointly participate in private activity.
Love to view another person.
Straight from the brief.
And I just want to jump in and talk about this locker room scenario because, I mean, I've been in a lot of gyms in my life, and I have seen a lot of things in a locker room that I thought were supposed to be private that were not. And I'm just saying,
Pat, how many assholes have you seen, like, up close?
I'm gonna plead the fifth. I'm gonna plead the fifth on that one.
I think he is saying that is 5 assholes.
I'm not gonna answer that question. But it's like, you know, but under this logic, he uses this locker room example, but essentially, taking his analogy one step further, if I want to go in there and just put on my iPhone and say, all right, well, y'all are walking around without a towel on here. If you didn't want to show me your dong, you shouldn't, you should have kept it on. Essentially, what's the difference between his theory in this case and, hypothetically, me as a sex pervert recording everybody in the gym?
I mean, it's a really...
Am I missing something? I don't think I am. Yeah. If I am, please tell me I'm wrong. But
yeah, no, I think that's right. If all of the people, in the sort of, typical locker room shower, which isn't individual stalls, it's just, like a dozen shower heads.
What?
Sticking out.
Wait, what? That's how guys' showers are?
A lot of
pretty much, yeah.
You just stand in there naked with each other and you just...
It's not like Oz.
Look
at but I mean, a lot of showers are like that. I mean, all of the shower scenes in all the teen movies where the creepers are jumping into the girls' locker room in high school.
Girls'
or whatever.
locker room showers are not
stalls.
like that. We have our own little rooms because we're civilized people.
So it's not like Porky's, is what you're telling me.
It's not like. I'm sorry to disappoint you. Anyway, back to the locker room.
But like anything, if you watch any prison show with a shower scene, that's basically what the shower looks like. Where it's just a bunch of showers, heads sticking out of the wall, and everyone sort of
looks at the wall
You avoid
stares very carefully at the wall,
or each other's dogs. Depending on where
and so, but that is right, Pat. That is the same analogy. Everyone is there with limited expectation of privacy, right? You're only expecting to be viewed by the other person in the room, and I guess he would say that. I guess the way he would thread the needle here is he would say that all of the people who are showering at the same time have no expectation of privacy vis-a-vis each other. But if someone else had set up a live stream of the room, that person would be violating all of their privacy, right? That's how he would get himself into that same scenario where he's she had no expectation of privacy from me, but no one else should have been looking at the two of us. And since she had no expectation of privacy from me, my grotesque, threatening photo does not meet this very specific statute meant to capture a pervert who is different than my kind of pervert.
That theory eviscerates the social contract that you have when you're nude with another person. I mean, I've been naked with my wife, but I wouldn't want her taking pictures of me without my knowledge and sharing them with other people or whatnot. And I'm sure the other married people on the podcast will say the same thing. It's maybe this is too of a textual reading, but his theory seems to say that as long as you allow yourself to kind of be vulnerable in front of another person, they can do whatever they'd like at that point. You're giving up all these rights and kind of consenting to, them surreptitiously even recording you two having sex for your own use later on, which seems to me to be exactly what the revenge porn statute is written to prevent.
Yeah. Right, though he says that's not. His argument is that it's not a revenge porn statute.
Right.
His argument is that it specifically addressed. Right, it specifically addressed two things. Right, there are two sections of it. One refers to an expectation of privacy in a private place, which is the kind of dressing room, locker room scenario. And then the other one is a sort of narrower expectation of privacy in a public place, which seems a lot more like upskirt photos.
Right.
And things like that. So he's then this is where he gets into the legislative history. Mm-hmm. And he's so if you look at what they said about it at the time, these are the problems they were trying to address. And this is why they wrote the statute in these ways that they did. But it still seems not to confront the nature of what privacy is. She was consensually naked in front of him. She was not consenting, and explicitly, she wasn't consenting to be photographed. And he clearly, the threat also seems to indicate that he knew that there was no consent there, right? I'm going to take this picture while you're blindfolded and I will threaten you with it. And she told, to get back to something I was saying earlier, she told this story to her husband, who she didn't know was recorded. Right?
While confessing the entire affair.
Right. While confessing the affair, she's like, so the recording is her with like in a scenario where she is not like under oath as part of the prosecution. Like she's not even particularly negatively disposed towards him, you know, though she's sort of apologizing to her husband for everything that happened or whatever. But she didn't know she was being recorded at the time. And then he leaked the I don't remember the exact sequence. I don't know. I don't think he turned it over to prosecutors. I think he just turned it over to the press.
This poor woman, like she just cannot like stop getting recorded or taken pictures of, like when she's not consenting.
So is the husband the one who's funded by Soros then?
Oh my God.
No, that's the district attorney.
Okay.
So I guess the supplement to the MTD is that the Missouri GOP has, blamed the prosecution on the eternal Jew. Said that
all those
Kim
St.
Gardner,
Louis
the district
liberals,
attorney,
all
has
12 of
received more
them.
than 200,000 from George Soros groups.
I keep checking my mailbox. Man.
No.
Any day now. Any day now, Charles.
Any day I'll get that check. It's funny. She does keep getting recorded, and she's like literally the only sympathetic one here because the husband really
he's an asshole.
Also kind of comes off as
huge piece of shit.
Huge piece of shit because like I guess her name really isn't in the press because most people are not printing it. But I mean, he's the guy who leaked it. He's in the press, and so it's like his wife, and he was just doing it to get after the guy
who cucked him.
The guy who cucked him.
So do me a favor, like everyone who's listening to this podcast, and please look up Governor Greitens because he extremely looks like someone who would revenge porn his
he's the
mistress.
worst. I mean, we have to talk about this because, he has a number of books that he's written and his Amazon author name is Eric Greitens, Navy SEAL.
Oh,
right. He's got a number of books written about like one is The Heart and the Fist. About and then he has written a number of police ethics courses or something.
That's right. He his complete warrior ethics curriculum.
It's like guerrilla mindset, but for Republicans.
Police officers
one page
in the late.
It's
2000s.
1 page long.
Is that capitalized? Does he have like a trademark on that, Adam?
I think it's in all caps in the tweet I'm seeing.
Well, I like how he was the guy who had the political ads where one of them involved him using, I believe it was either an M4 or an AR-15 to shoot a barrel that exploded in a field. Yeah. And the other one was just him unloading a minigun into a lake.
Yes.
Basically saying, I hate the environment so much, I'm going to shoot up this lake with a minigun. Vote for me against the libs.
I mean, he looks like Mike Cernovich.
His eyes are a little bit farther apart than Mike's. Let's give him credit in that respect. And his face is less
square,
squished in other ways as well. He's not using the nootropics, which I think is
that was his mistake.
Yeah, that was his mistake. Yeah. If he hadn't, he wouldn't have been caught.
Let's do 5 points.
Everyone back? All right, we should do 5 points. That's number 3 for today, folks. Our last topic is the recent litigation over the 5 Points building in Queens. I don't know how many people are familiar with this, but if you Google 5 Points with his
Points. Sorry.
Yeah, that is how they pronounce it. It's another thing that I get wrong, just pronouncing it points like a sucker.
Like an old white guy.
It was just a building, a warehouse, like a derelict warehouse building that sat in a useless, undeveloped part of Long Island City in Queens for decades. That the owner of the building had essentially turned over to one graffiti artist, Jonathan Cohen, just to let him curate everything. And like every inch of this place was covered in aerosol work. On the outside, it was like a multi-story building, and like from the sidewalk to the roof was covered, and all the interior walls were covered.
It's cool. You guys should look it up. It looked really cool.
Really, really cool, good work. And then in the intervening decades, the property actually became worth something, and the guy decided to turn it into a, he was going to tear it down and turn it into condos.
Luxury condos.
And luxury condos, of course, because no one makes cheap condos anymore in New York. And so he was going to tear it down, turn it into luxury condos. And all of the graffiti artists who had been working on this thing forever tried to stop it in various ways. They tried to get an injunction against it. They tried to buy it. And they almost raised enough money to buy it when it was worth like $40 million. But then he got like a building variance he needed that would have allowed him to make it into condos instead of, I guess, whatever industrial use it was zoned for before that. And as soon as he got condo permission, the property went from being worth $40 million to $200 million. And that was it. Like the 5 Points people couldn't raise that kind of scratch. And so they were done. And so they sued under VARA, which is, I think, the Visual Artists Recognition Act. I don't want to screw up that act.
Visual Artist Rights Act.
Visual Artists Rights Act. Recognition is one of the rights under that umbrella. So the Visual Artists Right, they tried to get an injunction stopping him from tearing down the building. And they lost the TRO application. The judge denied them the preliminary injunction. And the second he denied the preliminary injunction, the developer sent in crews with buckets of paint and rollers and just whitewashed the whole goddamn
overnight.
Cheaply.
It was like a TV villain kind of shit.
Well,
like
I thought it was interesting that when the TRO was denied, the judge still warned Wolkoff was the building owner, that if he did anything to like fuck up this art, that he was opening himself up to a VARA lawsuit and serious potential damages. But he was essentially apparently enough of an asshole that he didn't care, and was full steam ahead at that point.
I think he was really. It's funny, like the levels of anger in here, because I think he was really pissed that he let these guys tag up his building for so long, and he thought that he was like super generous in doing so. And I think like it's funny, like in this sort of sympathy for the devil kind of way, that I think he felt incredibly betrayed.
Yeah.
He did,
right?
yeah.
100%.
He sits on this property for decades. He lets them tag it up, and then as soon as he can do something with the property, they all turn on him, just like like he's just like, I knew they would do this to me all along.
Yeah.
Like, they only pretended to think I was cool.
But the thing is, like, a couple things, right? Like, number one, as you said, like the property increased in value tremendously over the time that he permitted this to occur. And I think there was a sort of undercurrent in the decision where, frankly, the fact that these folks had made this into, a a landmark in some respects, really inured to his benefit as the owner of the property, right? And the second thing is, I've said this on Twitter a bunch of times, but my feeling about litigation is generally this. The judge is going to figure out who the asshole is and make them lose. And he did everything he could to be the asshole in this case, and he lost.
That's why Tarik does so poorly in court.
I mean, what's funny is I think that's a democratic judicial philosophy. Yeah. Whereas it really seems like textualism is designed for assholes.
Yeah, that's right.
Like textualism is a legal principle which was put in place by extensive lobbying by assholes.
That's right.
And so what ended up happening is he whitewashes the building, and what was initially a suit for an injunction, for various reasons, either a permanent injunction or an injunction that allowed them to remove whatever art could be removed. Like some of it almost certainly couldn't have been removed because the same people who couldn't afford to buy the building also couldn't have afforded to sort of lift a 4-story work of art off the side of the building. But there were smaller pieces that could have been cut off of interior walls,
drywall,
or things like that. Yeah, things that were put up on drywall or on or doors, removable materials, right? There was a lot of stuff that could have been removed had he allowed it. And so they end up suing for damages. And they, unlike a lot of cases where people are familiar where the damages are the amount of harm you receive, VARA, like a lot of similar statutes in intellectual property, has what are called statutory damages, where the statute itself says a piece of art that is ruined in violation of VARA is worth this amount, right? And it, like the original, I think the statute says around $30,000 per, with the exception that if the damage was done willfully, then it jumps to 150,000.
Right.
Exactly.
There is to sort of bring this back to the last pod's episode in the discussion of deterrence.
There was no last pod.
There is, well, to bring it back to the non-existent Slender Man discussion of deterrence, which happened, I guess, in the ether. There's a deterrence prong in VARA when the judge is deciding on, what sort of damages to assess.
Yeah, and in this case, he found a bunch of things willful. I mean, first of all, just the whitewashing and the kind of slapdash whitewashing where it didn't even really necessarily cover everything. Like you could literally, the building was visible from the 7 train, like the elevated line.
Like millions of people saw this every week.
It's basically a commuter train into Manhattan, from Jackson Heights and Elmhurst and, is an elevated line that goes right past the building. And from the train, you could see the ghost of the art underneath, this one thin layer of white paint. So he just sort of ruined everything. And this was sort of really a big part of the judge's opinion, where he's like, you did it without, I warned you that this would happen if you did it. And then you did it. And then you were a huge pain in the ass when you were testing.
Yeah.
Getting
this gets back to what you were saying in the episode 5 with the death penalty, right? You can tell in the first few sentences what's going to happen, and then under Roman numeral 1, he says,
hated the guy.
On November 12th, 2013, after a hearing, court issued an order denying preliminary injunctive relief, stating that a written opinion would soon be issued. Rather than wait for the court's opinion, which was issued 8 days later, Wolkoff destroyed almost all the paintings by whitewashing them. So in the first 3 sentences, where this is going.
So how much money did they end up getting? It's millions of dollars, right?
$6.7 million, I believe, was the total amount for all of the artists.
Yeah.
Which was, he went through, there were 49. Right, the statutory standard is that they had to have. I'm going to get the terminology wrong because I don't have it in front of me. but they had to have achieved a level of recognition. And so a lot of this stuff didn't fall under the statute.
Recognized stature.
And a lot of it didn't fall under the statute either because it was too new or because it was not even recognized by the 5 Points people as being particularly important. Like they would give prominent placement, like the
you could
stuff
see from the train
on the exterior walls, the stuff you could see from the train, all of that would go to like the recognized artists, the really talented people. And then other people would rotate through almost like apprenticeships, and they would just cover each other's work, like with permission, not like really aggressive, like graffiti war bombing kind of shit. But like there would be like one part of the wall where they're like, you can have this space for 2 months. Yeah, they knew their stuff was getting covered, but they could photograph it and they could say they were in the 5 Points community. And if it was good enough, like the people who run the place would just be like, no one can ever cover this. Right. And so it could like achieve stature by the acclaim of the community, and so like, I mean, and the judge lays out like all of this history and how things achieved stature. And then he goes one by one through the 49 pieces that the artists claimed had received stature. And he agrees on 45.
This poor jury. And I cannot imagine.
Oh, well,
there's another interesting part about that, too, right? Because the jury sat through this whole trial.
Someone tell us about the jury.
So procedurally, at some point towards the end of the trial, the plaintiffs waived their jury rights.
And it was like a 3-week trial.
Statements.
Yeah. It was a jury trial. There were 8 jurors who sat through the whole thing. And at some point, like right at the end, the plaintiffs waived the jury rights.
Which, by the way, like you could tell they waived their jury rights because like those first 3 sentences of the opinion must have been on the judge's face the whole time. Like, I mean, the judge's opinion, like
he was so mad.
Quotes from the trial colloquy where he's trying to drag a responsive answer out of Wolkoff. And so at some point, clearly, plaintiff's counsel was like, guys, the judge fucking hates this guy.
Yeah. And
there's no way he rules against
He consented to the waiver.
I believe the language used by the judge was that the defendant had been motivated by pure pique and revenge of the nerve of plaintiffs to attempt to sue to prevent the destruction of their art. And I mean, that is that tells you
he hated him,
how he felt in no uncertain terms.
Right. Okay. So Tarik,
they sit through this whole trial, and at the end, the plaintiffs waive their jury rights. So the judge converts the jury to an advisory jury, but doesn't tell the jury.
Because they had been working so hard that he didn't want to like hurt their feelings.
He has a whole section about how great they were. They were always on time. They paid attention. They sat through all this stuff, and
There were like 50 exhibits, like pieces of art. And he's like, they took each one seriously and they they paid attention during the history of each of the pieces of art, all of the artists. And some of them like were from outside of the country. Like all of the artists either came or testified by
Skype,
video.
yeah.
Like they all came in and made sure to like defend their own artwork. And so now they're an advisory jury.
They don't know it,
which the federal rules allow them to do, but he doesn't tell them, and so they just deliberate normally, and they come back and they say, I think they said like 39 or something, like not quite as many as the judge. Like they thought that more of them had not achieved stature,
and they awarded about $1 million, something like that.
Yeah. And so then the judge takes it. He goes, I agree with all of the ones that you think achieved stature. He said, thanks very much. Your opinion on like all of this is hugely useful to me. I think all of the ones that you think achieved stature did, but also these 6. And also, thank you for your damages ruling. But I, as the judge, have the discretion to find willfulness.
Yep.
and I find willfulness on all of them, and so it's $150,000 per for 45 different
the max. He gave him the max.
I mean, part of this to me seems though like really shitty lawyering on the defendant's part that they let their client get on the stand like that.
Well, it's client control issues. I mean, like that's,
he
let him whitewash
it. Yeah, he was so confrontational, and he was, if you're going to fight with the judge and basically admit to every element of a willfulness statute, it's like, Jesus Christ, if I'm his lawyer, I'm, getting an ulcer listening to him do this. I'm trying to object.
And that after he made an ass of himself on the stand and the plaintiff said, well, we'd like to waive our jury rights, they consented to the waiver.
They're like, yeah, it's fine.
Hubris. It's his hubris.
But you know what? Like, in the greater scheme of things, this building is worth $200 million right now. They're getting a $7 million ding. Like, it doesn't matter. Like, that's really, I feel like, the long and short of it.
Right. And I agree with Christina in that
respect.
Only
in New York.
The judge mentioned the deterrent effect multiple times. He's like, look, I'm giving you the full statutory damages to get that deterrent effect. And it's like, all right, well, I'm getting a profit of, he bought the building in the early 70s. It's now worth $200 million. 6.7 is, it's a drop in the bucket, essentially.
Yeah.
I mean, and it's what he dismissed, I think at an earlier stage of the litigation. One of the things that the artists tried to claim was that their artwork contributed to the value. Right. And so they were trying to get the $200 million.
They should have done,
which I think explains why he fought so hard so early.
Yeah. They should have had some sort of wild adverse possession theory. Let's try to create some new law for Winnell property students.
Oh, no. They didn't. I don't think they claimed adverse possession.
That would be so cool if they did.
They should have. That would have been more interesting facts.
In other countries, they would have had a stronger moral rights argument. I think that VAR isn't particularly strong as far as moral rights go. This point is actually courtesy of my friend who wrote a paper about 5 points in law school. But other countries have much stronger moral rights laws that basically they can, civil law countries can, if your work is obtained certain stature, you can prevent any sort of defacement or altering of it.
But again, there's really no doubt that they increased the value of his property.
Right.
Whether they succeeded or not,
increasing the hipness of the neighborhood mostly. Right. They probably didn't directly increase the value of the building because he's going to knock all that shit down. But the presence of 5 points was important to turning Long Island City from an industrial zone,
wasteland when we were kids, right?
All the coffee
into
shops,
a residential neighborhood.
Yeah, all the coffee shops and bars that are there right now are only there because this existed.
Yeah,
and that's a driver. Yeah, I mean, I don't live in New York, but I assume that's a driver for yuppies that want to move to the Queens for some reason.
Yeah. I mean, just to get to 1 point, they had no good adverse possession. Okay. Because they were there with his consent.
Exactly.
So basically, they had moral rights to both of D's nuts.
That was shoehorned in.
I've been thinking that.
There is no way. I opened myself up.
Slackbot.
Have you considered the Bofa ruling, Charles?
Bofa boys rule.
See bio.
So it just really was the opinion was just so mean to him because they so clearly hated him. I mean, there really was a lot of colloquy in the opinion of him just being
he's an asshole
on the stand.
And he lost. I'm telling you.
Yep.
At the trial level,
he's an asshole worth $200 million now. So it's
exactly. But you can, you can take your statutory interpretation at the appellate level, but at trial level, the asshole loses, and he lost.
Yeah. And the argument at the appellate level is clearly going to be that this, it can't mean that you can't knock down your own building. No. Whatever Vara is, they couldn't have stopped him. But the answer is going to be that there were other measures in place. You're supposed to give them 90 days notice.
Right.
And you just whitewashed the whole thing. And it also, I think he was also really mad because Vara didn't exist when he first let them in. And nothing like this will ever happen again on new buildings, because if Vara had existed at the time that he first let the artists into the building, he would have conditioned it all on waiving their Vara right. Like Vara has a waiver provision, and he never, ever would have allowed any of this to happen.
Well, when was Vara enacted?
Not that long ago.
It's new.
Okay,
I don't remember exactly when it was.
Because this didn't happen. Like 2013 is, I guess, when the first time he started making noises about turning this into condos.
Right, so, but it had been way before then.
Right, yeah.
That he had started allowing them to take up the place.
Right.
So like when he allowed the artists in, and Jonathan Cohen like apparently took like the curation really seriously, and like Wolkoff was hip enough to like know who to put in charge of, this community, and a well-recognized artist, which by the way also kind of indicates that Wolkoff knew what he was doing, right? Like he didn't just let a bunch of like kids with aerosol cans just start tagging shit all over the wall.
No, he had a whole plan.
He went and got a recognized artist to create a community in the building, which I think also kind of weakens his case. Like he knew what he was doing in terms of his own building, even though ultimately the judge decided that he could never figure out in any credible way what increase in value would have been attributed to the artist. So he just washed his hands of that whole issue and dismissed it. He's just like, he basically is like, it might be true that, you made the whole thing cooler, but you're like, I'm not awarding you $200 million and I'm just dismissing this whole claim.
A lot of assholes this week.
Anyone? Yes.
Jeez.
So that is, look, this podcast doesn't exist without assholes.
That's right. We're powered by
Neither does
assholes.
our profession.
It is the soil that Mike Dicta grows in.
Smells.
Is the
Smell
fertilizer of assholes. Anyone have any additional comments on this or any of our cases?
No.
That sounds like a no. So I'm going to wrap up episode 8/9 of Mike Dicta. I'd like to thank all of the panelists, Tarik and Christina and Adam and Pat. My name is Charles. Check out the SoundCloud for all of our handles, and we'll see you next week.
Good night,
folks. Thank you, everyone. Have a great night.